Good afternoon, Your Honor. Ms. Lockett, stand right next to Ms. Blair, please.
All right, I think we have almost everyone present and it's 2 o'clock, perfect timing. Okay, Ms. Middlebrooks, she's here too. All right, great. Our reset date should be 4/21. Is that correct, Ms. Middlebrooks?
Good morning, Your Honor. Yes, that's correct.
Okay, thank you. All right, good afternoon, ladies and gentlemen. My name is Judge Jessie Law, and this is going to be the Fulton State Expedited Accusation Calendar. This is a list of cases in which individuals were recently booked at the Fulton County Jail, and their cases have already been formally accused by the Solicitor General's Office of Fulton County, who is the prosecutor over these cases. Therefore, this case is now before the State Court of Fulton County, and this would be the defendant's initial appearance before a judicial officer. When I call your case, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Now, if you are a witness or an observer or a concerned family member or friend, and if you are driving a vehicle, please leave the Zoom conference. Will the host please remove Alfonso Colbert Jr. from the Zoom? Once Mr. Colbert is parked in a safe position, he can rejoin the calendar. All right. Again, this is a virtual open court. We do record the proceedings and everything is live streamed. So I expect you to be addressed accordingly, appropriately. And also, if you are an alleged victim in the case, you have the opportunity to address the court if you choose to do so. I would have to place you under oath. If you do not want to address the court, that is also your right. Okay. Courtroom 2, who do we have, please?
Judge, if we can do a breakout session with courtroom 1 and the PD, Ms. Johnson, and an interpreter case for position number 15, please. And then we can start with South Annex, and then we can come to courtroom 2. Thank you.
Thank you. All right, will the host please place courtroom 1, myself, and who needs to be in the breakout? Ms. Melnick?
Judge, I didn't get a request for an interpreter, so do we need a Spanish interpreter?
I do not know.
Yes, it's supposed to be a Spanish interpreter for position number 15, Mr. Lopez.
All right, does Mr. Lopez need a Spanish interpreter? Is that the language we require?
Yes, Judge.
All right, we do not have an interpreter on hold right now. And so who is representing Mr. Lopez?
I'm representing Mr. Lopez, Judge.
All right, Ms. Johnston, have you conferred with him at all?
No, Judge, I haven't been able to because there was not an interpreter available for me to speak with him. All
right. I can only reset the case to Monday, and we will have an interpreter available at the C calendar.
That's fine, Judge.
Okay. Courtroom 1, if you can unmute your screen. Mr. Lopez, do you speak a little English? Poquito English? ¿Se habla inglés?
Poquito.
Poquito. No interpreter. So we see you on Monday. Do you understand?
No, no entiendo muy bien.
No?
No.
Monday.
El lunes, señor.
Monday?
Monday,
Sí.
yes.
Sí.
All right, gracias. Position 15 is reset to Monday, this coming Monday at 2 p.m. and we'll need a Spanish interpreter on Zoom. All right, moving back to courtroom 2, who do we have, please?
Judge, we can start with South Annex first, please, and then you come back to courtroom 2, please.
All right, will do. Deputy Milton, are we ready to proceed?
Yes, Your Honor, before you is position number 2, Ms. Blair.
All right. We have Demaya Renee Blair, accused of simple battery domestic violence in case 22 CR 002120J. Ms. Blair, you've been advised of your right to remain silent, and your attorney is going to be Ms.
Maureen
Johnson.
McLeod.
Ms. McLeod, okay?
Yes, Your Honor.
Thank you. All right. Who's prosecuting this matter?
I am, Your Honor, Jordan Reiser on behalf of the state.
All right. And Ms. Reiser, was there a dual arrest in this case?
I do not believe so, Your Honor.
Okay, just verifying. Thank you. Ms. Roberts, with pretrial, may we have any priors on Ms. Blair?
This is our first arrest.
Her first arrest?
Yes.
Okay. All right. Ms. Reiser, what's your recommendation for bond?
This state would recommend a $5,000 surety bond to have no further violent contact with the victim, Michael Towns, and to have no drugs, weapon, or alcohol while out on bond. Your Honor, our office did make contact with the victim, and that's what he requested. Is Your Honor familiar with the facts of the case?
Yes, I am. So how many children do they share?
From
2, Your Honor.
Two.
2 children
And the incident occurred at her location, right? Not at his.
at the 3200 Stone Road, Atlanta, Georgia. That's
Okay.
correct. I believe so.
All right, thank you.
And that is my client's home.
Okay.
Mhm.
Ms. McLeod, I'm going to issue a 3,500 signature bond through pretrial services. And she may return to her home. She will report to pretrial once a month. She's not to consume any illegal drugs, no alcoholic beverages, and no weapons and no firearms. I'm not too certain about the no further violent contact. I understand that is his wish, but given the circumstances and how this incident arose, at the present time, it's no further contact with Michael Towns. I will allow for a third-party transfer of the children they share, but he cannot, she has to stay 200 yards away from him and not communicate with him in any way, form, or manner. And Ms. Blair, you will report to pretrial once a month. You will be subject to random screens for alcohol and drugs. You will also attend and complete a one-day anger awareness program with the Fulton County Pretrial Services. If you get arrested again, if you fail a drug or alcohol screen, or if you engage with Mr. Towns, which will require the authorities to get involved, you could lose your signature bond and be back in court on a cash or surety bond. Your next court date will be sent to you at your current mailing address. Thank you.
Anna, may I say something concerning the parties? My client tells me that she and Mr. Towns have been in a relationship since she was approximately 19 years old. She's now 28 years old. They do share an 8-year-old and I believe a 4-year-old child. It has been a relationship of significant length, and this is the first incident between them. So I think no contact at all probably sets the parties up for failure, Your Honor, because I think a 10-year relationship just doesn't go away because there has been one incident between the parties.
Ms. McLeod, I do not know if this is a solitary incident. I just know this is an incident involving the officers. And if you'd like me to recitate the alleged warrant, this is an altercation that allegedly occurred in which then the defendant jumped onto a moving vehicle and was allegedly under the influence of alcohol during the course of this entire incident. So I would say at the present time, I would prefer a cooling off period. And down the road, if things are in a better state of situation, I would be glad to remove the no further contact to no further violent contact.
Thank you, Your Honor.
All right. Mr. Towns, at the present time, Ms. Blair is required to stay 200 yards away from you, not communicate with you in any way, form, or manner. So in order to avoid her being in trouble with the law, I highly recommend that you stay away from her, and that if you need to see the children, you would need to get a third party involved to arrange visitation with the children. Do you understand, sir?
Yes, ma'am.
All right. That concludes this case. Thank you.
Next, we have position 16, Ms. Luckett.
We have Zantea Luckett, accused of battery, domestic violence, and cruelty in the third degree with regards to case number 22 CR 002-132H from April 8th, 2022. Ms. Luckett, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kinsey Johnson. Is that correct?
Yes, Judge.
All right. And pre-trial, do we have any priors on Ms. Luckett?
One prior from February 15th of this year for 4 counts of cruelty in the first degree. Case number is 22 CP 206662. And I believe the victim in this case is one of the victims in one of those counts.
All right, thank you. Ms. Melnick, is it?
Yes, Your Honor. Good
Okay.
afternoon.
Good afternoon.
Yes, she has a prior conviction that is still open with our office and just recently. So this would technically be a violation of that probation and that, not probation, I'm sorry, violation of her bond conditions. She does, the defendant has a co-defendant, Sean Stewart, who's also on. So we have not been able to speak to him about, obviously, about what his wishes are with this. However, we would ask for a $5,000 good bond.
Ms. Johnson?
Yes, Judge. Ms. Luckett would be asking for a signature bond on this case. The alleged victim was also arrested, and in the facts alleged, he was the first one to make violent contact with Ms. Luckett. Due to those facts, I would be asking for a signature bond. She is a mother. She has children she needs to provide for. She also has a job to go back to upon release. And for those reasons, we'd be asking for the signature bond.
All right.
Also a student, sorry, Judge. She is also currently a student.
Oh, where at?
At UEI.
I'm sorry, what is that?
I'm not sure, Your Honor. That's all the information I have. Ms. Luckett might be able to.
Where is she attending classes, Ms. Luckett? If you want to just let me know where you're a student.
Yes.
Yes, ma'am. I'm a student for medical assistant
Where?
at UEI in Morrow, Georgia.
What is
United
UEI?
Education Institute. It's an institute, like a second-based program where you can get your GED and get your credentials.
All right. I'm trying to see, you were just released in February. And
Judge, if I may, the facts of
yeah,
the previous.
well, my concern is just the status of a bond. She's got a $10,000 good bond in the other case. All right. Okay. On the battery domestic violence, that's going to be a $1,500 good bond. On the cruelty matter, that's going to be $500. That's going to be a $2,000 good bond. She's to have no further contact with Sean Stewart. And I just need to clarify, the child or the children she shares with Mr. Stewart, are they married, or were the children born out of wedlock? Anybody can answer that, Ms. Luckett or Ms. Johnson.
Judge, I believe they are not married.
Okay. All right. So with regards to the child or children, I couldn't recall from the warrant whether there was more than one. But if there are more than one, then there shall be no third-party transfer of the children. If Mr. Stewart seeks to have visitation or custody of the child or children, he may file a legitimation action. But she's to have no further contact with Sean Stewart, no weapons, no drugs, illegal drugs, and no alcoholic beverages. Her next court date will be April 21st, 2022. If she does make bond, her next court date will be sent to her at a current mailing address. And I believe we have a Morrow Road in Forest Park. Is that the correct address?
Yes, Judge.
All right. Thank you very much. Next case, please, Deputy Milton.
That's it from the South Annex, Your Honor. Thank you for everything.
Oh, all right, you're welcome. You have a good weekend. Thank you. Courtroom 2, are we ready to proceed?
Yes, Judge, if I can give the announcements, please, on the reset for this calendar, please.
Certainly.
Position number 3, medical reset, Brown.
Okay,
Position number 7, Colbert, medical reset.
all right. Just 1 second. We had something on the chat asking whether a Gregory Colbert is going to be on this calendar. He is on the calendar, but we're going to reset his case to Monday. All right, please continue.
Position number 13, Mr. King, medical reset.
Good heavens, okay.
Position number 14, Mr. Lewis, medical reset. And I have position number 17, Ms. South in the chair.
All
Thank
right, thank you. Okay, we have Kimball South, case number 22 CR 002-133A, accused of battery, domestic violence from an April 8th, 2022 incident. Ms. South, you've been advised of your right to remain silent, and your attorney is going to be Ms.
Maureen
McLeod.
McLeod.
Okay. And
Maureen McLeod.
yes, all right. And Ms. Roberts, I understand she qualifies for pretrial services?
She does. Her last arrest was in 2019 for battery. That case was dismissed.
Okay, thank you. Ms. Melnick, what's your recommendation?
Yes, Your Honor. She also has a 1982, she has a simple assault. We have spoken to the victim in this case, who is her son, and he says his mother does have a medical condition which he thinks has affected her, and he's not scared of her and wants her home. So the state was asking for a 5,000 signature bond to go through pretrial to help monitor the situation.
All right. Ms. McLeod, I'm going to grant a $5,000 signature bond through pretrial services. No further violent contact with the victim. And I'm sorry, I didn't catch his name.
His name is Daryl South, D-A-R-R-Y-L.
Daryl South? Okay,
Yes.
with a Y. Okay.
Yes.
No further violent contact with Daryl South. Okay.
And Your Honor also asked for no drugs or alcohol and no weapons.
All right, thank you. Ms. South, based on what Daryl South has said, it appears that you qualify for what we call a signature bond, which means you don't have to pay for your bond today, but this is still an active criminal case against you. So you're going to have to comply with certain conditions and come back to court when summoned. Do you understand, ma'am?
Yes, ma'am.
All right. So your next court date is going to be sent to you at your current mailing address. If you change your address, you need to let the court know first. You're not to consume any illegal drugs, no alcoholic beverages, and no weapons and no firearms. You're also not to have any physical or verbal altercations with Daryl South that will result in the police being involved. If there are any future altercations and you're arrested again, this current bond, $5,000, will switch to a surety or a cash bond, which means you will have to pay to be released the next time.
Yes, ma'am.
All right. If you are undergoing any kind of treatment, I expect you to continue with said treatment and to comply with all medication to which you've been prescribed.
Thank you. I will, ma'am.
All right. Please keep in mind, your next court date will be sent to you to your mailing address. Your attorney is Maureen McLeod, and you would need to keep in touch with her to find out what's going on with your case.
All right.
All right. Thank you. Anything else, Ms. McLeod?
No, Your Honor, that will be all.
Oh.
I see that the court is aware that she is quite sick, you know.
I'm sorry, I can't tell from here, but I'll take all your words for it. Okay?
Yes, Your Honor.
All right, thank you. Next case, please.
Position number 4, please.
All right. We have State versus John Joseph Burns, accusation number 22 CR 002-123J. Mr. Burns has been accused of driving hit and run, driving under the influence of alcohol less safe, and driving under the influence of alcohol per se. This is from an April 8th, 2022 incident. Mr. Burns has been advised of his right to remain silent, and his attorney is going to be Ms. Armstrong.
Yes, Judge. Good morning or afternoon. I always do that.
You know, when your day begins in the morning, they all sort of blend into one time zone. So
thank you for understanding things.
All right. So with regards to Mr. Burns, Ms. Roberts, I understand he doesn't have any priors.
That's correct.
All right. Ms. Reiser, what's your recommendation?
Yes, Your Honor. Mr. Burns's bond on the count of hit and run is currently set at a 1,000 surety. The state would like to keep it as set. On the DUI less safe, it is currently set at a $1,000 surety. We would request that it stay set at that. And onto the DUI per se, the state is requesting a 5,000 surety with the conditions of no driving unless permitted by DDS and no drugs, alcohol, or weapons while out on bond, and random screens if possible, Your Honor.
And I'm assuming the per se charge is based on the fact that it's pending results, correct?
Yes, Your Honor. He did give a blood test, and that was notated in the warrant. I just don't have those results at this moment, but pending those results, Your Honor.
Understood. Thank you. Ms. Armstrong?
Yes, Judge. If Your Honor is not inclined to grant a signature bond on the counts 1 and 2, we would also ask that the $1,000 be set. But we do not agree with a $5,000 bond, especially since the results are pending. My client did admit to the officers pursuant to their questioning that he did take Ambien. He was prescribed Ambien, but we would ask Your Honor not to impose a $5,000 bond on a charge that we don't even have test results for. My client was compliant in the investigation. We would argue that there was no reasonable suspicion to turn what was an alleged hit and run into a DUI investigation. And my client is from the Atlanta area. He's recently unemployed, but right now, given his finances, it does not appear that he qualifies for a public defender. So I have advised him to reach out to certain private DUI defense attorneys in the area. But we would ask for the per se count for nothing more than 1,000, just so it's equal to the other two.
All right, thank you. On the DUI, under the influence of alcohol, less safe, I'm going to keep that at $1,000 surety. On the hit and run and the driving under the influence of alcohol per se, that's going to be a $2,500 signature bond through pretrial services. So his total bond will be $6,000. It's a split bond. He would have to obtain a surety bond on $1,000, and he can sign out on the remainder $5,000 signature bond through pretrial services. The conditions to the bond is no illegal drugs and no alcohol at all. No driving unless he's permitted to do so by the Department of Driver Services pursuant to a license suspension hearing. And also no driving when he has consumed any prescription medication. I don't know, is Ambien a prescription?
Yes, Judge.
Okay. His next court date is going to be April 21, 2022, unless he bonds out. And once he bonds out, then he will be given a new court date and that will be mailed to his current address.
Your Honor.
Yes, Ms. Reiser?
Is he going through the signature bond, is that through pretrial or will that be through the jail?
Pretrial services.
What about the random screens?
Oh, I was just about to get that.
I'm so sorry, Your Honor.
That's all right. That's all right. As I was saying, no illegal drugs and no alcohol consumption. He will be subject to random screening by pretrial services. If he fails a screen, if he gets arrested again for anything else, if he fails to report to pretrial, then his the signature portion of his bond, the $5,000, will be reverted to a surety or cash bond. All right, Mr. Burns, are you able to make the $1,000 good bond?
Yes.
All right. And if you do so, make sure, as you've been advised by the Public Defender's Office, you may not qualify for their services. So I highly recommend that as soon as you're released, you retain the services of a defense attorney, because there are certain other steps that you would have to take in addition to dealing with this criminal case to preserve your driving privileges.
Okay.
All right. Thank you.
Thank you.
Position number 8 is next, Judge.
Thank you. We have Samario DeAndre Collier, accused of driving hit and run, improper turn, failure to obey a traffic control device, and driving while license suspended or revoked from a September 24th, 2021 incident. case number 22 CR 002126G. Mr. Collier, you've been advised of your right to remain silent, and your attorney is going to be Miss Armstrong. Is it Miss Armstrong?
Yes, Judge. I couldn't click my unmute button quick enough. I apologize.
No problem, no problem. Okay, Ms. Roberts, any priors on Mr. Collier?
Only one prior from 2019 for marijuana possession, and that case was dismissed.
All right, thank you. Ms. Reiser?
Yes, Your Honor, the state's recommendation as to the count of hit and run, we are requesting a $2,000 surety. On the improper turn, we are requesting a $500 surety. On the failure to obey traffic control signs, $500 surety. And the driving on a suspended license will be a $2,000 surety. That would make it a total of a $5,000 surety. And with the conditions of no driving unless permitted by DDS or with a valid license, and then no drugs, weapons, or alcohol while out on bond.
Okay. So this happened in September of 2021. Do you know if, oh, all right, I see the Sandy Springs hold. Okay, understood. All right, Ms. Armstrong?
Yes, Judge. In reviewing the incident report, there's no direct evidence identifying my my client. He's in custody. Today he's a victim. My client as the driver of this vehicle. There's nothing to say describing his, to the best of my recollection, describing what he looked like, that he was the driver of the car. Nothing that indicated he was driving the vehicle. Moreover, the vehicle is not in his name. It actually belonged to somebody else. When law enforcement contacted that third party, they said, oh, well, I had lent my car to the defendant. So, you know, who knows who else he was lending his car to. The owner of the vehicle was aware of the accident. It's quite possible that the owner of the vehicle was the driver that night and claimed he lent it to somebody else. So we do not find it reasonable to keep this individual in custody on a $5,000 surety bond where there's no direct evidence linking him to actually driving the car. So we are asking Your Honor to set the bond on each count no more than 500 surety, if not signature bonds, and also would ask you to do so in recognition of his lack of criminal history, especially any violent criminal history.
Oh, okay. But he does have a Sandy Springs hold, so I don't know whether that's keeping him at the jail or whether he can be released to the hole or whether he can go there on his own. So, but meanwhile, his on the driving hit and run and driving while license suspended, that's going to be $1,000 each. And the improper turn and failure to obey a traffic control device is $500 each. Total bond is $3,000. There's a signature bond through pretrial services. No driving unless he has a valid current driver's license that's not suspended or revoked or expired. He has to have adequate automobile insurance on the vehicle he's driving, and the vehicle does have to have proper registration. So make sure you check all three boxes before you operate a motor vehicle. Your next court date will be sent to you at your current address, and the address we have is a Piedmont Avenue location. Is that the correct address?
Yes, Your Honor.
All right. And could you tell the deputy your current cell phone number and email as well, and put that in the chat? Deputy, if we could send that information to pretrial services, please.
Yes, Judge.
All right. Thank you.
You're welcome.
Anything else? No, I think that's it.
Oh, no.
No.
Position number 9 is next.
All right, Mr. Al Valentino Dorsey Jr., case number 22 CR 002127Y, accused of simple battery domestic violence from a July 8th, 2021 incident. This is Mr. Dorsey. He looks a little perplexed, so I just want to be sure. Are you Mr. Dorsey?
Yes.
All right. So, Mr. Dorsey, this is the reason why you're here is from a July 8th, 2021 incident.
Yes.
Mr. Dorsey, you've been advised of your right to remain silent, and your attorney is going to be Ms. Sarah Armstrong. Ms. Roberts, any priors on Mr. Dorsey?
7 priors, a theft by shoplifting conviction from 2015, 1 FTA from 2015, and then 3 probation violations in his history.
Were they prior to 2015?
The last was in 2015.
All right. Ms. Melnick, is it? Oh, Ms. Reiser, sorry.
Yes, Judge. The state's recommendation as to the bond on count 1 would be a $5,000 surety. No further contact with the victim, Joshua Rucker. Stay away from the incident location of 2090 Bent Creek Way Southwest in Atlanta, Georgia, and to have no drugs, weapons, or alcohol while out on bond. Your Honor, that recommendation is based on the facts, not only his criminal history. We believe he has a flight risk as he does have 2 VOPs and 1 failure to appear, and just does have some prior convictions, Your Honor.
Okay, noted. Ms. Armstrong?
Yes, Judge. Looking at the police report, I'm a little confused how we are here in the first place. This happened back in July of 2021. At the time, the complaining witness, he refused to actually provide the defendant's name and any identifying information. So based on the police report, they didn't even identify my client as being the alleged perpetrator at the time. My client is not a flight risk. He lives in Atlanta. He is employed as a chef at a well-known restaurant. He lives here. He pays his own rent. And to the best of my recollection, and Mr. Rucker, you of course can correct me if I'm wrong, but it does appear they're on good standing. At least they're cordial right now. And my client will report to court when called. We're asking for a signature bond based on the lack of violent criminal history, as I recall it being stated.
I'm here.
All right. Understood. First of all, well, thank you for being here, Mr. Rucker. I just am a little perplexed by the address. The address is 2090 Bent Creek Parkway, but he's got a different address. So, Mr. Rucker, did you want to add anything to the court? I need to place you under oath. I need to place you under oath. Other right hand.
Oh, sorry.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Do you and Mr. Dorsey cohabitate in the same location?
Yes.
All right. And the location is 2090 or something like 1994? I couldn't remember.
Yes, ma'am. I just relocated.
So you do not live at 2090 Bent Creek anymore?
No, ma'am. I moved back in August of last year.
To 1994?
Yes, ma'am. It's the same complex. They just moved me into another space.
I see. And do you still both occupy the same premises?
Yes, ma'am.
All right. What would you like to tell me?
If it can help, me and Mr. Dorsey have been on good terms. It was just like a incident that went wrong that night. Both of us were just kind of angry, and I was just trying to, just get attention or something like that. I asked the court to throw it out, but I know the state do pick it up. But me and Mr. Dorsey are engaged now to get married. We just adopted a child together, and we actually just built our own business together. So for them to try to keep us away would be a lot. But we have not been into no incident. We are now taking counseling and everything now to stronger our relationship. So now we are engaged to get married. So I wouldn't want Mr. Dorsey to be away from me because we have built a lot now since the incident. The incident is really old, and I tried to tell them that I didn't want to go forward with it. But if they can just please just leave the case alone with me and Mr. Dorsey, because we are doing good. No one told me to tell this, and I actually love this man. We are planning to get married this year, and I hope that we can still get married and they do not keep us away from each other.
$1,500 signature bond through pretrial services. I guess you can say per judge for that one. No further violent contact with Joshua Rucker. No stay away. No illegal drugs, and well, I'm sorry you work in the food business, but no alcoholic beverages and no weapons and no firearms. You report to pretrial once a month, and if you get arrested again for anything else, this signature bond will convert to a surety bond or a cash bond. All right, thank you. Your next court date will be sent to your current address, I guess, at the 1994 unit number.
Thank you.
All right, thank you.
Position number 10 is next, please.
Ryan Hartsfield, 22 CR 002128E, is accused of battery domestic violence from March 4th, 2022. Mr. Hartsfield, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kinsey Johnson. Okay, Ms. Roberts, any priors?
2 priors, with the last being in 2007 for willful obstruction and criminal trespass, which was not on docket.
All right, thank you. Ms. Reiser, what's your recommendation?
Yes, Your Honor, the state's recommendation as to count 1 would be a $5,000 surety. No further contact with the victim, Tiffany. Her last name is Feliciano. And a stay away from 234 Maple Place Northeast if she is still residing there, and to have no drugs, alcohol, or weapons while out on bond, Your Honor.
All right. And Ms. Johnston?
Yes, Judge. We would be asking for a signature bond on this case. For some background, Mr. Hartsfield has lived in Atlanta since he was 3 years old. He has a job right now. He's a manager at Restaurant Depot. If he were to be released from jail, he would be able to go back to work. His manager is aware of the situation, and he would be able to keep working if he was released. He does live in Atlanta with his girlfriend, Miss Feliciano, who is the alleged victim in this case. She is on the link right now and would like to speak with Your Honor about this matter. Mr. Hartsfield and Miss Feliciano both assert that this was a trip down the stairs, that they don't have problems like this in their relationship. They want to have contact with each other. She wants Mr. Hartsfield to come home, and we would be asking for a signature bond on this case.
All right, thank you. Ms. Feliciano, if you want to address the court, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. So this didn't happen too long ago. What would you like to say?
No, it didn't happen too long ago, but since then we have reconciled. We actually spent some time apart. I don't know him to be a violent person. I don't even know him to have a temper. Things happen. It's unfortunate, but we both learned from it. And I'm asking for you to bring him back home, please, on his signature bond.
All right. Do y'all still live at the same location, 234 Maple Street?
We do, yes. Mm-hmm.
I'm a little concerned about the allegations in the warrant. I believe you were trying to leave the premises?
Yeah, so we were in an argument. I had decided to leave, and I actually was locked out. So I got back into the house. He was upset that I got back into the house. And on the way down the stairs, he nudged me with his knee, and I fell and I slipped. So, but that was it. He's never put his hands on me. We've never had an argument like that ever in life. We've been together for a year now, and it's always been good terms, but again, it's unfortunate, but.
All right. Bonds can be set at $3,500. It's going to be a signature bond through pretrial services. No further violent contact with Tiffany Feliciano. He may return to the location, but if there are any future verbal or physical altercations, Mr. Hartsfield will unfortunately be back in jail, and next time will be on a surety or cash bond only. No illegal drugs, no alcoholic beverages. He will report to pretrial once a month and be subject to random screening for drugs and or alcohol. He will also undertake a one-day anger awareness class through pretrial services, and his next court date will be sent to his Maple Place address. Thank you.
Judge, that was no further violent contact, correct?
Yes, no further violent contact, yes.
Position number 12 is next, Judge, please.
We have Keandre Jones, accused of obstruction and terroristic threats from April 8th, 2022. Mr. Keandre Jones, case number is 22 CR 002-129Y. Mr. Jones, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kinsey Johnston. Any priors, Ms. Roberts?
No.
All right. And he's what, 17?
18, I believe. I thought he was 17.
Okay.
I think he's 18.
All right. And Ms. Reiser, is it? Oh, Ms. Melnick, yes.
Yes, Your Honor.
Go ahead. You may give me a recommendation.
Yes, Your Honor. I know that this was a first, I have his first arrest. However, he was trying to fight with the victim's father through a police officer. The victim was packing up her stuff to leave him, and then her father was coming to pick her up. And then when the father got there, the defendant was, and the officer was there, the defendant was trying to fight through him and threatened to hurt him. The act of violence is very discerning to the state, and we would ask for a $5,000 good bond with no drugs and alcohol. Stay away from Jetta Harvey and her father, and no weapons.
Do you have the father's name, please?
The police report is silent on that, and we have not been able to contact the victim on this.
All right.
And Judge, he's not charged with a crime against the father of the woman mentioned in the report.
This is not quite true, but he is charged with it that way.
Well, I've got the obstruction charge on the warrant. I'm just was wondering whether the alleged terroristic threat involved the alleged victim, Miss Harvey, and her parent as well. So if the warrants are silent on that, then we'll move on. Ms. Johnson, what's your recommendation?
Yes, Judge, we would be asking for a signature bond on this case. Mr. Jones is a high school student. He may be 18, but he's still a child in many senses of the word. I also have his mother here on the link who is willing to speak on the record to your honor. He has school on Monday. He has no violent history. No arrest history, period. He also has epilepsy. He suffers from health issues. So that's a concern with him being held in the jail. And obviously he doesn't, because he's a high school student, he doesn't have the income to pay a $5,000 bond. If the court is willing, I think Ms. Jones would like to say a word.
Is it Ms. Tamika Jones?
Yes, ma'am.
All right. Ms. Jones, do you currently rent or own your home? Because you'll need to co-sign his bond.
I currently rent my home.
Okay. And do you have a utility bill that shows your name on it with that address?
Yes, ma'am.
All right. So you'll need to bring your driver's license or any government issued ID, as well as the utility bill to pretrial services, and co-sign his release bond. Do you understand?
I do.
All right. And he's going to be subject to some strict conditions. If he doesn't comply with those conditions, well, then I can only do so much.
Can I ask you a question?
Sure.
When this incident happened with the officer, Jada and her father had left. So he never said anything after they left towards the victim, because he made the father come back and tried to get him to press charges, and the father refused. I don't even know his name. And she was actually in my home uninvited.
Oh dear. Okay. Well, it's a good thing she left, right?
Yes. And so they were already gone.
Okay.
So when he asked, did he want to press charges, the dad said no. But Keandre is a high school student. He plays basketball. He's set to graduate next month. I just asked that you show mercy.
Okay. Well, actually, I'm more concerned about, I think the terroristic threats is based primarily on his conduct with the officer. So more so than with the Harveys.
Yes, ma'am. He does have some mental health issues as far as, growing up and trying to work with him. I understand he's 18, but I just think it could have been handled a different way.
I agree. Okay, Keandre, on your obstruction charge, your bond is going to be set at 1,500. On the terroristic threat is 1,000. Your total bond is 2,500. It's a signature bond through pretrial services. Your mom, Tamika Jones, and I'm assuming that's your correct spelling on your name on your screen.
Yes, ma'am.
All right. Ms. Jones will come down and co-sign this signature bond. You're to have no further contact with Jada Harvey and her family members, which means that you are to stay 200 yards away from Jada. You're not to communicate with her in any way, form, or manner, including a cell phone, a computer device, a third party, in person, or on any kind of social media platform. You cannot discuss Jada or even reference her. Engaging in any kind of communication with her may result in you coming back to jail and staying here for a significant period of time. Do you understand? All right. No illegal drugs, no alcohol, and no weapons and no firearms, and you will report to pretrial once a month until this case is resolved. Your next court date will be sent to you at your address, and we have a Niski Lake Road address. Is that the correct address?
Yes.
All right. Okay. All right. Good luck. And Ms. Jones, make sure your son works with his attorney at the public defender's office, and maybe they can resolve it so that it doesn't impact his future.
All right. Thank you.
All right. Good luck.
Position number 18 is next, please.
All right. We have Sean Stewart, accused of battery and domestic violence and cruelty in the third degree with regards to 22 CR 002134F. And this would be a cross defendant, yes?
That is correct, Your Honor.
All right. And Mr. Stewart, you've been advised of your right to remain silent. And Ms. McLeod, do you represent him?
I do, Your Honor.
All right. Ms. Roberts, any priors on Mr. Stewart?
5 cycles. Last arrest was from December of 2020 for driving while license suspended or revoked. That was no priors, and he has no felony or misdemeanor convictions on his GCS.
All right, thank you. Ms. Melnick?
Yes, Your Honor. Yes, Your Honor. He's had several arrests with no convictions. Apparently they were living together, but you did say that to have no contact. So given that, we would ask for a $5,000 good bond with no contact at all with the victim in this case, Miss Luckett. And also to have no drugs or alcohol and no weapons, and to stay away from 470 Bolton Road, Atlanta, Georgia.
And that's where Miss Luckett lives, right?
Yes, correct.
Okay.
Your Honor?
Yes, Ms. McLeod?
We would oppose this good bond, this surety bond, Your Honor. My client has no convictions. He tells me that he was the victim in this case, that he was actually attacked by Miss Luckett. She knocked him out and he was unconscious. He went to his mother's house when he came back from unconsciousness. He called the police from his mother's home. He went to 3 different precincts because he wasn't sure which precinct he actually lived in, just to complain about what happened. And the police told him that if she said something different, they would arrest them both. Even though my client actually has injuries, he was injured because he was knocked out. He says he has never put his hand on Miss Luckett, and it wasn't a situation of mutual combat. She attacked him, Your Honor. He is a good candidate for a signature bond because he does not have a record, and he was not the aggressor here. He was actually the victim. So therefore, I would ask the court to consider giving him a signature bond so he can get out of jail. They do share a child who is only 11 months old. He has a child. He's actually the primary custodian of the child right now, Your Honor.
Okay, I'm a little confused. So the child he shares with Miss Luckett, and then he has another child. Is that correct?
No, Your Honor, this is a child. he has this child and he is the one, and this is his home, incidentally. She doesn't live there.
Right, she's to stay away from that location.
Right, Your Honor, but this is his home, and he is the one who has primary custody of this child.
Your Honor, unfortunately, we don't have a jury here for Ms. McLeod because we're arguing the facts here. The fact that both of them were injured, which is why the officers charged both of them. And she had visible injuries on her, which is why we charged her with battery family violence. And again, we're asking for a $5,000 good bond.
I understand. My more concern is that if I allow a signature bond, I do not want either one of them to have contact with each other.
He's fine with that, Your Honor.
All right. And if the child is born out of wedlock, I believe I told Ms. Luckett that he would have to legitimate the child in order to have custody and visitation. But
the
you're
police
telling
gave
me
him
that,
custody, Your Honor. There's like, she can't keep the child.
who gave him custody?
The police took the child to him some time ago because of a previous incident with Miss Lockett.
Your Honor, that is not in evidence here today. In fact, when the police came there, the child was with Miss Lockett. So unless we have some court order or some documentation, which I'm sure we would get to have a bond hearing, then I don't think that that's going to be admissible because the child was in her custody.
At his house.
Both of their houses. In fact, she was there present. They both used their houses as they both used the same address as his house.
It's his house.
Where's the documentation? It's both of their houses.
Ms. Melnick, good heavens. We're not going to and fro. I'm going to leave the tennis match to someone else. All right?
Your Honor,
but Ms. McLeod, no, I mean, right now we have, first appearance, we deal with strangers and we try to ascertain information. And both sides are always hedging on information. And I'm just trying to get a bond so that people can move forward. So
I understand, Your Honor.
Right now, with Miss Luckett, I gave her a good bond, no further contact with Sean Stewart, and that he is required to legitimate the child. These two, apparently, the incident arose out of a visitation issue. So if he doesn't have a court order giving him custody of the child, then he doesn't have custody of this child. He has no visitation rights over this child. The fact that the police handed the child over to him does not rise to the level of legal custody.
I understand that, Your Honor. I do a lot of family law myself. But what I'm saying, he was the one who called the police. He was the one who was actually knocked unconscious. He is the victim. Sometimes men are the victim.
I'm not adjudicating his guilt or innocence. I'm just trying to establish his bond, and I'm going to grant him a signature bond.
Thank you, Your
With
Honor.
regards to the child, if he is in possession of the child, and if Miss Luckett makes bond, she has every right to demand that child back from him.
I understand, Your Honor.
All right, then we are on the same page then. Okay. So with regards to Mr. Sean Stewart on the battery, it's going to be a $2,500 signature bond through pretrial services, and the cruelty is going to be $1,000. That's going to be a $3,500 signature bond through pretrial services. He is to have no further contact with Miss Luckett and Zentia, wasn't it? Zentaya, Zamtiya. He is not to consume any illegal drugs, no alcoholic beverages, and he will report to pretrial once a month and be subject to random screens. He may return to the 470 Bolton Road, Atlanta location as long as Miss Luckett does not reside and does not live there. All right?
So I just want to clarify, so we don't have any miscommunications. I'm not trying to do a tennis match. I do apologize, but they both listed that address on to the police as that was their address.
Okay, so she has no further contact with Sean Stewart. So if he lives there, then she cannot return to that location.
They both live there.
I know.
She does not live there. It is his.
Stop, ladies, please stop. Please stop. All right. He can return to 470 Bolton Drive. And Miss Middlebrooks, with regards to Miss Luckett's bond order, please make a note that she has to stay away from 470 Bolton Drive, and that she would need to update the court within 30 days of a new address. Okay.
Yes.
All right. Moving on. Mr. Sean Stewart, while he's out on pretrial, will complete a one-day anger awareness class.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may, Ms. McLeod. Enjoy this beautiful day. It's a little nippy.
Thank you. You too, Your Honor.
Enjoy it. Thank you.
Position number 19 is next, Judge.
All right, Mr. Young.
Yes, ma'am.
All right. Mr. Baldy Young is charged with criminal trespass and damage to property in accusation 22 CR 002135F. Mr. Young, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kinsey Johnston. And any priors, Ms. Roberts?
Yes, he has 12 priors, with the last being in 2019 for purchase, possession, manufacture, distribution, or sale of marijuana. That case was, there's no disposition listed.
Okay.
Carter, he also has a 2014 parole violation, a 2008 FTA, an 08 ag assault and cocaine, an 07 drug possession, an 07 manufacturing of drugs, a 06 possession of controlled substance, and 05 dangerous drugs.
All right. And with that history, what do you recommend, Ms. Melnick?
We're asking for a $5,000 good bond and to have no further contact with the victim in this case.
And that would be
Renetta Bolton, and to stay away from the address of 2192 Larchwood Road, Southwest in Atlanta.
Okay. Ms. Johnson.
Yes, Judge. On this case, I'll point out that Mr. Young has lived in Atlanta since 1996. He does have a job right now. He works as a vendor at Atlanta Braves games, and upon release, he would be able to go back to work and continue working. He lives in Atlanta currently. I have also spoken with the alleged victim in this case, Miss Gwinnetta Bolton, who is here on the link and is willing to speak with Your Honor.
All right, thank you. All right, Miss Gwinnetta B. Bolton. All right, you may unmute your screen.
Yes, ma'am.
All right, would you like to address the court about this case involving Mr. Young?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. So how do you know Mr. Young?
He's my husband.
Are you both married?
Yes.
All right. Is there a TPO against him right now?
No, ma'am. The incident is actually you was my judge when I was arrested because Mr. Young made up a report about a necklace he wanted. When I called the police, he placed a warrant on me while I was at work.
Oh, I'm sorry. So he's got a you've got a restraining order against you.
Right. Right. It was in place when I came out of your courtroom. Once I left your courtroom, Mr. Young bust my window. And I called the police. He did pay for the window.
What do you mean by your courtroom? Was I the one who issued the restraining order?
Yes, ma'am, because he placed a warrant on me with making false statements while I was at work.
Judge,
so I've been trying to get cleared.
I'm okay. All right, understood. All right. Thank you, Ms. Bolton. Thank you. You may unmute your screen. Yes, Ms. Johnston.
Judge, if I may inquire with Ms. Bolton. Did she leave? Ms.
No,
Bolton?
she's there. You can unmute.
Okay. Ms. Bolton, yes. Ms. Bolton, do you have any, are you in fear of the defendant in this case?
No, I'm not in fear of him. I just don't like when he tears up my property.
Do you have any issues with him being released from jail on a signature bond?
No, ma'am, I don't have any problem with that. I just want to get this whole thing cleared away so I can clear my name.
Thank you. That's all for me, Your Honor.
All right. Mr. Young, it's going to be a $5,000 signature bond through the jail. All right. And which means you can sign up for your bond, but you're not to have any contact with Ms. Gwinnetta Bolton. Please unmute.
Ma'am, we're married and all my property is there. And
All right, now you're gonna hear me. Now you're
I
gonna
was just
hear.
asking this in any way that I can get somebody to come get my possessions, all my clothes, everything. She got my jewelry. This is my wife. I'm like, and it's more of a tit for tat. She was mad about.
So,
last
so
part.
Mr. Young, please be quiet. Otherwise, the deputy is going to mute the screen again. All right? Yes, this is an unfortunate spousal dispute, and you have a $5,000 signature bond through the jail. You don't have to report to pretrial, but this is an active criminal case against you. Criminal court is not here to help you in your divorce. You have a court order requiring you now to stay 200 yards away from her and not communicate with her in any way, form, or manner. If you want to resolve this, you can eat. No, you want to keep talking with me, then we're done. You are going to stay away from 2192 Lodgewood Road in Southwest Atlanta. You cannot be seen within 200 yards of that location. All right. Now, if you want to retrieve your personal belongings, you are allowed to go back there one time only, with a police officer, and that visit cannot exceed 2 hours. Within that 2 hours, you retrieve whatever belongings you want, and if there's any dispute about any of the belongings, you cannot touch that item, and you have to leave it there for divorce court to figure it out. You can only pick up the items where there is no dispute that you're allowed to have them. And this visit cannot exceed 2 hours. And if you believe you have a lot of stuff, you can bring a U-Haul truck with you, as long as there's a police officer accompanying you at that time. Now we can unmute the screen.
I have a 2-year-old daughter. Is it any way that I can't see my daughter, maybe?
Your visitation with your daughter will be done only through a third-party transfer. In other words, there has to be a neutral third party who will communicate with Ms. Bolton and with you with regards to how to pick up your child. You can see your child and then have the child return. In the alternative, you can get visitation and a visitation or custody schedule issued by family court in a divorce action. All right, that concludes this case. Thank you.
Does we have position add-on number 1, please?
Yep, Mr. Lamont. All right, Mr. Lamont Hall is case 22 CR 002137G, accused of battery, domestic violence. Mr. Hall, you've been advised of your right to remain silent, and your attorney will be Ms. Kinsey Johnston. Any priors, Ms. Roberts?
3 priors, all out of Virginia, with the last one being from 2014 for simple assault. And I said 3 priors, I meant 5, sorry. That simple assault was dismissed. Yeah.
Thank you. And Ms. Reiser?
Yes, Your Honor, the state's recommendation for bond would be a $5,000 surety. No further contact with the victim, Zayreana Ballard, Zayreanna Ballard. Stay away from the incident location of 4060 Janice Drive in East Point, and no drugs, alcohol, weapons while out on bond, Your Honor. While this is his first arrest in Georgia, he does have cycles out of from pretrial, I think it's Virginia, and 5 of those cycles, and they do involve violence. So based on the facts and his history, we would request this surety bond, Your Honor.
All right.
Guys, just for the record, I'm sorry, it's Pennsylvania, not Virginia.
Yeah, Pennsylvania. I didn't want to.
Okay, I was trying to find something in Virginia, these documents we have, but okay, thank you. Pennsylvania. All right, that makes sense. Ms. Johnson?
Yes, Judge. Mr. Hall has lived in Atlanta for about 4 to 5 years now. He does have a job at the moment. He works full-time at the Juicy Crab, and would be able to return to work upon release from the jail. He does also have asthma. which is a condition that can affect him in the jail with all of the coronavirus going on right now. We would be asking for a signature bond on this. I did attempt to make contact with the alleged victim, but I was not able to.
All right. With regards to Mr. Hall on the battery domestic violence, the bond's going to be set at 5,000. That's going to be a signature bond through pretrial services. He is to have, all right, I guess he changed his mind. He is to have no contact whatsoever with Zayreana Ballard, Zayreanna, last name Ballard, Ballard. He is to stay away from 4060-F1 Janice Drive in East Point, Georgia. He may return to that location one time only with a police officer to retrieve his personal belongings. That visit cannot exceed 2 hours. Upon being released through pretrial, he will have to update the court with his new address within 30 days. He may return to the Janice Drive location if Miss Ballard does not reside there, but as long as she resides there, he cannot return to that location.
Okay.
Yes, sir. Yes, Mr. Hall, what's the question?
The 4060 Janice Drive, that's my address. That's my apartment.
Does she live there?
No, she don't.
This is a battery domestic violence and situation, and it appears that she said.
Judge, they don't live together.
All right.
And that was something I was also going to point out, that the charge is battery family violence, but there's nothing alleged in the incident report that they live together or have children together.
Ms. Reiser, do you have any? I'm just concluding.
Yes, Your Honor. I think that the warrant that the officer had obtained was for family violence. It was my understanding, based on reading the warrant, that they had lived together or previously lived together. Of course, I can, look at the police report a little bit further, but for right now, I think it's charged appropriately based on the officer's warrants and speaking with the victim.
Okay. Well, I don't see a Miss Ballard on the Zoom. So, Mr. Hall, you can return to the Janice Drive home as long as she doesn't live there. So you can return first time with a police officer. And with the police officer, as long as it's verified that she doesn't live there and she doesn't occupy the premises, then you can return to that location. But if she's living there, then you can't enter the building until she vacates the premises. Do you understand? Okay. Like I said, it's going to be a signature bond. You will complete a one-day anger awareness program. No illegal drugs, no alcohol, no weapons, and no firearms. No contact with Miss Ballard means staying 200 yards away from her. Do not communicate with her in any way, form, or manner. And do you all share children together?
Yes.
Ah, bingo. Domestic violence. Okay. Okay. How old's the child?
We got our own newborn baby and a 2-year-old.
Okay. So have you legitimated the child or the children?
Oh, no, I plan on doing that in the future, as soon as I can, actually.
All right. So no contact with the 2 children until you file a legitimation action with the Superior Court in the appropriate county and you obtain a court order establishing visitation and custody.
Okay.
All right. That concludes this case. Thank you.
Next we have number 1, Mr. Artis.
Kendall Javon Artis is accused of criminal trespass, case number 22 CR 00212-002121F. Trespass at the Lenox Mall on April 8th. Mr. Artis, you've been advised of your right to remain silent, and your attorney is going to be Miss someone. Miss, oh, there she is, Miss Armstrong. Okay. All right. Yes, Miss Roberts, I'm familiar with his criminal history record. Ms. Reiser, is there a particular reason we should have a good bond for this particular matter?
Absolutely, Your Honor. It's currently set at a $2,000 surety. The state would ask to up it to $5,000 based on the history as reflected. and to stay away from the Lenox Square Mall address, and then have no drugs, weapons, or alcohol. Your Honor, I know you're familiar with it. I mean, his 20 cycles, all of them are criminal trespass or disorderly conduct convictions that were reduced down. He has an open indictment currently out of DeKalb from 2019, where it's a criminal damage in the second. He's currently under indictment in Fulton County Superior for criminal damage in the second, burglary, theft of services.
Yes, I'm all familiar with that. So
Yes.
other than not listening to the officers the first time around, I guess he just didn't get the memo the first time around, allegedly. Okay. Ms.
Correct, Your
Armstrong?
Honor.
I'm sorry, Ms. Reiser, I wasn't sure if you were done. I didn't
Oh,
wanna-
no, I'm done. Yeah.
She
Judge,
wants
I
me
just
to
wanted to-
increase, she wants me to give him a higher bond amount. so-
Yes, just,
Right.
yeah. Mhm. But I'm finished, Ms. Armstrong, go ahead.
Thank you. You know, we are going to ask for a signature bond despite the criminal history. We do acknowledge that the history is what it is. But Judge, we don't have the benefit of the notice, any notice that was given to the defendant. We don't know if it was written. We don't know if it was verbal. Based on what the defendant reported to me, he didn't understand that it wasn't just a one-time thing, that it actually was extended. You know, despite whatever is alleged in the incident report. Judge, there's no indication that he was trespassed from Lenox for disorderly conduct, for any drug use, for stealing anything. I mean, if we would ask Your Honor not to consider any facts to that effect. It's just a criminal trespass. And I do want to note that the way that this was accused would not survive a general demur. I understand we're here for bond, but the way that this case is accused, it neglects to include an essential element of the accusation, of the alleged crime. And statute says that you have to note in an accusation that the defendant was trespassed by somebody in authority to do so. And the accusation does not include that. It just says that he was given notice not to go to Lenox and that he allegedly knowingly went back. So given the defects on this case on its face, I am asking Your Honor to consider a signature bond. He will come to court. I'm happy to update the court with his latest address. Unfortunately, Mr. Artist, I didn't get your apartment number, so if we can get that notice, so you can get your notice to come to court for this criminal trespass.
Okay. Courtroom 2, would you be able to obtain Mr. Artis's apartment number so that we can get an updated address? Okay. Bond is going to be set at $2,500. It's going to be a signature bond through the jail. So Mr. Artis, you have a signature bond through the jail. I don't know whether he's paying attention. Unmute courtroom 2, please.
I was listening, Judge. I heard everything you said.
Well, hear this part.
Yes, ma'am.
You cannot return to the entire Lenox Square Mall, not in its parking lot, not in its sidewalks, and you're not to return until you get a court order that says you can.
Can you give me a court order? So, because they confiscated my money and my credit cards.
All right. You cannot return to Lenox Square Mall anytime.
Okay.
Until you get a court order that says you can. And right now, you're not getting that.
Okay.
All right. You have to stay 200 yards away from the entire Lenox Square Mall.
Can I send the child of my mother to get the money?
Absolutely no one.
But I have like $5,000 there in cash they have.
All right. And as soon as we go to trial, I'm sure this is a subject that will come up.
Okay.
But at the present time, you are not to return to Lenox Square Mall, and no one's to go there on your behalf. And your next court date will be sent to you at your current mailing address.
Okay.
And if you get arrested again for anything else, I'm going to authorize that this signature bond be converted to a cash bond only.
Okay.
It doesn't matter whether it's a written notice or a verbal notice. I don't really need to have a written notice that you were trespassed from Lenox Square Mall, but this is on Zoom being recorded, and it will be in your bond order that you cannot return to the entire Lenox Square Mall until further order of the court. Do you understand?
I understand that.
Excellent. Thank you.
All right.
Next case, please.
Yes, it's number 5, Mr. Kasem.
Which number is this, Your Honor?
11, I believe.
Sorry.
Number 3 or 11? I thought I heard 11.
Number 5.
Number 5, I think it's Mr. Kaysen.
Kaysen, yes, okay. All right, Antonio Kaysen has been, and is it Kaysen?
No, it's Kaysan.
Kaysan, all right.
Yeah.
Antonio Kaysan, accused of battery, domestic violence, and cruelty in the 3rd degree from a November 16, 2020 incident involving one Travell Carson, case number 22 CR 002124C. Mr. Kaysan, you've been advised of your right to remain silent, and your attorney is going to be Ms. Sarah Armstrong. Ms. Roberts, any priors?
He has 9 priors, with the last arrest being from Texas from 2016 for a traffic offense. And then he had 1 conviction for domestic violence out of Mississippi, or I'm sorry, that's not Mississippi, Michigan. From 2008.
Does he have a Clayton County hold?
He appears to have a Clayton County hold for death of service from July 19, 2021.
Oh. Ms. Reiser?
Yes, Your Honor. State's bond recommendation as to the battery charge, battery family violence, be a $5,000 surety. On the cruelty charge would be a $2,500 surety for a total of $7,500 surety. No further contact with the victim, Travell Casson, and stay away from the incident location, and no drugs, weapons, or alcohol while out on bond, Your Honor. I know you're familiar with the facts, but the state's recommendation is based on those facts, the injuries, and the defendant's own admissions, as well as the children being present during this altercation, Your Honor.
All right, thank you. Ms. Armstrong, did you want to add something, or did you want me to address Mrs. Kaysan first?
Mrs. Kaysen first, thank you.
All right. Mrs. Kaysan, I do see you on the Zoom. If you want to start your video and unmute your screen, if you have something to add, otherwise you're free to not say anything.
How you doing?
Fine, thank you. What's your first name, please?
Travell Kaysen.
Travell Kaysen. Okay, and Ms. Kaysen, may I place you under oath?
Yes.
Do you solemnly raise your right hand? I can't, oh, the other right, yeah. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Okay, this happened a couple of years ago, just over a year ago. Have you been living with Mr. Kaysen at all this time?
Yes, ma'am.
All right. And what would you like to tell me?
That he's the sole provider of us. I never wanted to pursue this incident. It was something that happened one time. We've been together 9 years and we have never had an altercation. So I would just like him to come home and just put all this behind us.
What do you mean you've never had an altercation?
Me and him never had an altercation together. Like, we never had a physical altercation. We argue with petty little marriage arguments.
And your name is Travell, Trevell?
Yes, ma'am.
And there's never been any physical altercation in the entire time you've been with him?
No physical ones, no, ma'am.
All right. Ms. Armstrong?
Judge, I am going to ask Your Honor to consider a signature bond in this case. As Ms. Cason indicated, he's the sole provider for the family. And just to clarify the context of when this incident allegedly occurred, the defendant and his family had moved from the Houston area to Atlanta for work. And ever since he moved here, he's been a forklift operator for a major company that I just won't say the name of since we're being recorded. But he's maintained that employment since he moved here in 2020. Unfortunately, he has missed up to 2 days of work, possibly tonight as well, since he does have the holdout of Clayton. But when I spoke with the complaining witness, she did indicate, as she just did on the record, that she's not in fear. This was an isolated incident, and that they've been together for nearly a decade. And this allegation is an isolated incident. And we do ask Your Honor to grant a signature bond. He will appear to the court when called. And also to clarify, the location where this happened was actually at a hotel where they were staying while they were obtaining housing, because they just moved to the Atlanta area. So we do need to update his address with the court.
All right. Do you have his current address? Would that be the Best Road location or something different?
It is something different. I apologize. I can ask courtroom 2 to call me so I can provide that too.
Is that the same location that he's sharing with Mrs. Cason?
Ms. Cason, is that where y'all live now? Okay, great.
Bond is going to be set on Mr. Cason for battery domestic violence. On the battery is going to be $3,500. On the cruelty matter is $1,500. It's going to be a $5,000 signature bond through pretrial services. I'm very concerned about the allegations right now made by Ms. Trebell Cason. They do not align at all with the sworn testimony that was provided by Officer Takesha Frazier when she swore out the warrant on November 16, 2020, before Judge Hannah Chung. The allegations set forth by Mrs. Cason are so diametrically opposite to the sworn testimony provided by the officer. And based on this discrepancy, I'm going to require that Mr. Cason have no further contact with Ms. Trebell Cason. He cannot return to the marital home. He would need to find alternative housing and update the court with his new address within 30 days of being released on the signature bond through pretrial. He may visit his children through third-party transfer of, which means that a neutral party will allow for visitation with the child or children he shares with Mrs. Cason. And in the meantime, he's not to consume any alcohol, no illegal drugs, and not possess any weapons or firearms. As noted, he is to make sure that he updates us with his current Georgia address if he's already lived in Georgia for quite a few years. Of course, once victim advocate has spoken to Mrs. Cason and the solicitor's office is satisfied that the situation is such that warrants lifting or amending the condition from no further contact to no further violent contact, then the court will be open to reconsidering that. All right. Would we unmute courtroom 2? Mr. Cason, you have a right to remain silent. Anything you say, your statements can and will be used against you. I don't know if you have read the warrant in this case, so I would be very careful about what you say at the present time.
I just have a question. Since I'm the sole provider of this household, it's kind of hard. I don't make that much money. I'm already paying for one household. Now you got me paying for 2 households. It's kind of really, I literally cannot financially do that. I can't move out my house and get a hotel somewhere and pay for that while I'm paying for my household at home with my kids and wife. I'm physically strapped. And possibly I cannot do that. And my wife, she says she's not afraid of me. Since the incident, we have been together. We split up for a few days after the incident, but since the incident, we have been not separated other than when we didn't took vacations, so.
Mr. Cason, like I said, I don't know of all, I just have the sworn testimony from the police officer, and it's so opposite to what Mrs. Cason is saying that I'm really concerned that this may be a situation where the victim is not being forthright out of fear. So,
I'm not sure what.
Mrs. Cason, I would not say anything else until you speak to the solicitor's office. You might want to get a copy of the warrant and read it, and maybe talk to the victim advocates before we move on. Thank you. That concludes this case.
Judge, very briefly, I am deeply concerned that by not allowing him to be able to go back to the marital home, this is going to debase their entire family, just completely financially jeopardize them. Would Your Honor consider allowing him to take a family violence class, a parenting class, an anger management class in lieu of the no contact, no return provision?
All right. I could do this. I would allow for no further violent contact with Mrs. Cason. There shall be no future physical or verbal altercation. While he's out on a pretrial bond, he's going to undertake and complete a 12-week anger management class. And that will be at his own expense. He must start those classes within 30 days of being released.
Your Honor.
Yes, Ms. Rice?
Would the court consider, instead of 12 weeks of anger management, do the 24-week FVIP instead?
Well, Ms. Armstrong?
Since this is a DV case, and I think if the court is inclined to make the decision to have no further violent contact, we would be requesting then the 24-week FVIP class.
Right, he hasn't been convicted of this yet, and that's pursuant to the statutory requirements. So the anger management that Your Honor suggested initially is more appropriate.
Well, actually, the state is correct. I can still authorize a FVIP program, but at the present time, I'm going to do the 12-week anger management classes.
Thank you.
And that's going to be at his own expense. Now, down the road, if he qualifies for any other programs, FWIP is still something that he may have to do. So it's not a question of one substitutes for the other. All right?
Yes, thank you, Judge.
Okay. Mr. Cason, do you understand? Within 30 days of being released, you must show proof to pretrial services that you are enrolled in a qualified 12-week anger management program.
I understand.
And those will be at your expense. In addition to that, you are not to consume any illegal drugs, no alcoholic beverages, no weapons, and no firearms.
Yes, ma'am.
All right. Thank you. That concludes this case.
Number 6, Mr. Clark.
We have Brandon Clark, middle initial M, charged with simple battery domestic violence in 22 CR 002125H from December 31st, 2021. Mr. Clark, you've been advised of your right to remain silent. Your attorney is Ms. Sarah Armstrong. And any priors, Ms. Roberts?
5 priors, 3 out of Virginia, 2 out of Georgia, with the last arrest being 2019 for contempt of court out of Virginia. He had a 2019 driving while license suspended or revoked conviction in Douglas County. And nothing further to add.
I'm sorry, I didn't hear the first thing that you said, something about Virginia. 6 cycles?
5 cycles, 2 out of Georgia, 3 out of Virginia, with the
Okay.
last arrest being 2019 out of Virginia for contempt of court.
Okay, thank you. Ms. Reiser?
Yes, Your Honor, the state's recommendation as to count 1 would be a $5,000 surety bond, no further contact with the victim, Ms. Lakai Davis, and stay away from the 2828 Two Lakes Circle in Atlanta, Georgia, and to have no drugs, weapons, or alcohol while out on bond, Your Honor. You heard he does have some felony convictions out of Virginia, so he is a multi-state offender. He does have some conviction, or the 2019 conviction out of Douglas County. Based on the facts of the case, as well as his history, we believe that the surety would be appropriate, and the parties do share children together.
All right, thank you. Ms. Armstrong?
Thank you, Judge. The complaining witness is actually present if she may be heard first, if she wants to be heard.
All right, Ms. Davis, if you want to unmute your screen and start your video, please.
Yes, ma'am.
All right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. How do you know Mr. Clark?
He's the father of my kids. We have 2 kids together.
Mhm.
And this incident happened December, New Year's Eve. It was an incident. We had friends over. We got into an argument or whatever. I never pressed charges on Mr. Clark at all. I don't even know why this incident is brought back up. We haven't had no more incidents since this issue. He left for a couple of days to cool down. We've been good. We have 2 kids together, ages 4 and 5. He also helped me with my 2 other kids because I'm the only one here. We're not from where we came in here in 2017 from Virginia. So I don't have no family here or anything. He helps pick my other kids up. I have 2 older kids from previous marriage. So I'm not scared of Mr. Clark. We're good. I don't even know why this issue has been brought back up. I thought it was over and done. I told the officer named Angel, I told him that I did not want to press charges. I wanted Mr. Clark to leave and cool down for the moment. He left, came back. We've been good. We haven't had no more issues, problems, or anything. We done been on vacation twice and everything. I don't understand why this issue is still up because I did not press charges against him at all.
When did you not press charges?
When the officer came.
When?
December the 31st, 2021. The night the incident happened, he asked me that I want to press charges. I said, no, I just wanted Mr. Clark to leave the residence. And that's it. And
that's all you said?
Yes, ma'am. And he said if I wanted to press charges, that I would have to go to the precinct to press charges.
And what was the name of this officer?
I just know him as Angel.
And
it was Mr. Charles. It was a Mr. Charles. Angel came first, and then a Mr. Charles came.
All right. And that's all you told the officer? That you were not pressing charges?
Yes, ma'am. And I also had my friend out there at the time. I said I did not want to press charges. I just wanted him to leave the residence. But before the police even came, he already had left the residence.
Okay. All right, Ms. Armstrong.
Judge, yes. It does also indicate in the incident report that there were no visible marks of any violent crime inflicted upon the complaining witness. And as she stated, he is the sole provider. He actually just started a new business that involves driving people in the evening, and he actually has a job scheduled for tonight that if he's not out by 10, he will miss out on that job opportunity and actually have to pay the deposit that the customers have paid him to drive them around. So we do ask Your Honor to consider a signature bond. This was 4 months ago. As the complaining witness stated, there's been 0 issues since, and it is better for the complaining witness and their children if he's out working, and so he can provide for them. And that is in recognition of the criminal convictions out of Virginia. But we ask Your Honor to grant a signature bond so he can work for his family.
All right. First of all, I want to preface that in reading the warrant, the decision to prosecute Mr. Clark is not up to Ms. Lakai Davis. She has absolutely no say on whether this case moves forward. So based on the information that the officers received at the scene of the incident on December 31st, they can still move forward with the case, irrespective of whether the alleged victim said that she never wanted to prosecute or anything to that matter. I just want to put that out there because I don't want anyone to get the impression that in a domestic violence case, that the decision to prosecute is solely up to the alleged victim. So given that information, this appears to be another situation where the alleged victim is apparently recanting from the allegations set forth in the warrant. So I'm going to set a $5,000 signature bond through pretrial services and no further violent contact with Lakai Davis. He can return to the home. He is to have no violent contact with Ms. Lakai Davis, either physically or verbally. And if there are any future altercations and the police get involved, well, then he will have to come back to jail with $5,000 to pay to be released. While he's out on pretrial release, he will undertake a 12-week anger management program that's qualified, and he will pay for those classes, and he will do so within 30, he will begin those classes within 30 days of being released and placed on pretrial services. Yes, Mr. Clark.
Your Honor, the state would also ask, I think we had requested no drugs, alcohol, or weapons. I don't know if you stated
Yeah,
that.
I
or not.
normally put that as my standard. So yes, no drugs, alcohol, and no weapons and no firearms. If he owns any weapons, they have to be removed from the home.
Thank you, Your Honor.
Courtroom 2, did Mr. Clark want to say everything, or are we all good?
We're good.
Okay, we're good then. Thank you. Next case, please.
Mr. Hendricks, number 11.
All right, who do we have for position 11?
Mr. Hendricks.
All right, Mr. Hendricks, so what's your first name?
Tiffany.
All right, how do I address you?
As a man.
All right.
Sister.
Mr. Hendricks, you've been accused of criminal trespass from April 8th, 2022 in case number 22 CR 0021119F. And with regards to this charge, you've been advised of your right to remain silent. Your attorney is Ms. Kinsey Johnston. Any priors, Ms. Roberts?
73 priors. Last arrest was from January of 2020 for burglary in the first degree. That is an open probation case, 20 SC 174777. That was a 7-year sentence. I've counted at least 10 criminal trespass convictions, 5 disorderly conduct convictions, has another burglary conviction in 2016, 5 probation violations in his history, 2 FTAs, 2014, 2011.
Oh, that's good. Thank you. Thank you very much. Ms. Melnick?
Yes, Your Honor. As the court knows, we're here today for 2 things: not to argue a special demurrer, not to argue the facts because we don't have a jury here. We're going to argue 1, that is the defendant a risk to society, and 2, to reassure the court that he will appear back in court. He gave officers an address of 1328 Peachtree Street, or Peachtree First Presbyterian. And because I know the court wouldn't want anything to be said that's not quite verified, I went and called them this morning to see if they have any type of shelter or any type of outreach program, and they do not. They will not accept his mail. He cannot stay there, so he does not have an address. Number 2, so there is no reassurance that he will attend court again. And 2, going back to 2000, I'm not going to read it all because, like she said, there were 74. He has been arrested 3 or 4 to 5 times each year, except for the years he was in prison. He has at least 13 to 14 criminal trespasses. He has probably just that many FTAs and probation violations. Going back from 2011, probation violation, 2011 criminal trespass.
Oh, Miss Melnick, I know, but
okay,
just give me a bond amount.
So there's no reassurance he will be back in court because there is no verified address. I confirmed it. I took the initiative to do it. And then 2, he will continue to be a danger to society because he is consistently, almost every month of every year, except for when he was in prison, keep doing crimes. So the state is asking for a $10,000 good bond on this case.
All right. Ms. Johnston?
Yes, Judge. Mr. Hendricks has lived in Atlanta for about 15 years. I guess perhaps Ms. Melnick has done this research on his address. My understanding is that he does have a valid address right now. He'll be living with his grandmother, Miss Charlene Willer, and would be asking for a signature bond on this. I understand he has a very lengthy criminal history. However, the allegations in this are minimal, to say the least. The information I have is just remained on the property after being criminally trespassed. We don't know what happened on the property, how long he was allegedly on the property, if he talked to anyone on the property, if there were any, it doesn't seem like any other crimes happened on the property. Due to how minor those facts are, we would be asking for sorry, can I finish?
I'm sorry, I was coughing.
We would be asking for a lower than a $10,000 good bond on this. I would leave it in your discretion, Your Honor, at a reasonable amount for a misdemeanor charge.
Okay. Bond is set at $1,500. It is a surety bond, and his next court date is April 21st, and he's to stay away from the Midtown Apartments. I think it was 915 Peachtree Street. All right, and he's not to return to that location until further order of the court. So it's not a 30-day stay away, it's not a 60-day stay away. It's a stay away until you get a court order that says you can return to that location. And we'll need him to update us with his current mailing address, and no illegal drugs, no alcohol, and no weapons or firearms. Thank you. Next case, Deputy.
Hey, that's all we have in courtroom 2.
Oh, okay. All right. Thank you very much. We will see you next week then. Enjoy your weekend. Thank you. All right, let's go down the calendar, councils. We have position 1. It's a signature bond through the jail. Stay away from Lenox Mall. Position 2 was a 3,500 signature bond. Further notice. Position 3 is a medical reset. Position 4 is a 6,000 split bond. Reset dates April 21st unless he bonds out. Position 5 is a 5,000 signature bond through pretrial with an anger management program required. Position 6 is a $5,000 signature bond with a through pretrial with a anger management program required. Position 7 is a medical reset to Monday. Position 8 is a 3,000 signature bond through pretrial for the notice. Position 9 is a 1,500 signature bond through pretrial for the notice. Position 10 is a 3,500 signature bond through pretrial, and that's also going to be further notice. Position 11 is a $1,500 good bond, reset date April 21st. Position 12 is a 2,500 signature bond through pretrial. Further notice. Position 13 is a medical reset to Monday, same announcement. 14, Lewis, medical reset to Monday. 15 is a medical reset to Monday. 16, Luckett is a $2,000 good bond, further notice to April 21st. Miss Middlebrook, that's the one where she has to stay away from the Bolton Avenue location as well. Kimball South is a $5,000 signature bond for pretrial for the notice. Position 18 is a 3,500 signature bond through pretrial. And position 19 is, I believe that was a good bond, wasn't it? Bowdy Young? I didn't write that.
Sign on bond through the jail. I have $5,000 sign on bond through the jail.
Signature bond through the jail, okay. And our add-on was, I believe that was a signature bond through the jail, right? I'm so sorry, I wrote them down somewhere, but not on the paper. They should have been written down.
The add-on, I have a $5,000 sign on bond through pretrial.
Through pretrial, all right. Any questions? All right, thank you, folks. Enjoy your weekend. I really, it's gotten cold, so I don't know anything about this wonky weather, but y'all enjoy. Take care. Bye-bye.
Thank you, Judge.
All right. Ms. Middlebrooks, go ahead and email me the documents and then we'll review them. Thank you.
Yes, Judge.